Thank you very much. Please be seated. We'll go on the record in the matter of State of Utah versus Martin MacNeill. He is present with his counsel. The state's attorneys are present. We are outside the presence of the jury. Last evening, I indicated that I wanted to give the defense a more full opportunity to raise the directed verdict motion following the presentation of its evidence. Do you wish to do that?
Your Honor, I do wish to renew our motion for a directed verdict. I don't believe, however, that my arguments would be any different than the ones that we made at the close of the state's case. And so we would submit it based upon those same arguments.
Thank you. From the state.
Your Honor, I would just refer the court to our argument in response to the defendant's motion, and I would be happy to answer any questions if the court has them.
Based on the arguments presented, the court denies the motion for directed verdict as to both counts. Did each of you receive a copy of the closing jury instructions?
We did just now, Your Honor.
Yes, Your Honor.
Does the state take any exception to the instructions?
I imagine what we discussed yesterday afternoon, the state takes no exception.
From the defense?
No, Your Honor.
Thank you. Is there any housekeeping matter that needs to be addressed this morning before we begin?
Not from the state, Your Honor.
Or the defense.
Very good. Let's have them in. Thank you. Please be seated. We are on the record in the matter of State of Utah versus Martin Joseph MacNeill. He is present with his counsel. The state's attorneys are present, and the jury is now seated. Did we distribute those instructions yet? Ladies and gentlemen, the bailiff will provide to you a copy of the closing jury instructions. They've been 3-hole punched so that they can be placed in the binders that you have. If you'll each take a copy. By way of explanation of how we'll proceed today, I will provide to you these closing jury instructions. We will then hear closing argument from first the state, then the defense. Because the state has the burden of proof, the state will have the opportunity to speak last. You will then have the case submitted to you for deliberation. Let's begin with instruction number 13, if you would follow along. Members of the jury, you now have all the evidence. 3 things remain to be done. First, I will give you additional instructions that you will follow in deciding this case. Second, the lawyers will give their closing arguments. The prosecutor will go first, then the defense. Because the prosecution has the burden of proof, the prosecutor may give a rebuttal. Finally, you will go to the jury room to discuss and decide the case. Instruction number 14, juror duties. You have two main duties as jurors. The first is to decide from the evidence what the facts are. Deciding what the facts are is your job, not mine. The second duty is to take the law I give you in the instructions, apply it to the facts, and decide if the prosecution has proved the defendant guilty beyond a reasonable doubt. You are bound by your oath to follow the instructions that I give you, even if you personally disagree with them. This includes the instructions I gave you before trial, any instructions I may have given you during the trial, and these instructions. All the instructions are important. You should consider them as a whole. The order in which the instructions are given does not mean that some instructions are more important than others. Whether any particular instruction applies may depend upon what you decide are the true facts of the case. If an instruction applies only to facts or circumstances you find do not exist, you may disregard that instruction. Perform your duties fairly. Do not let any bias, sympathy, or prejudice that you may feel toward one side or the other influence your decision in any way. You must also not let yourselves be influenced by public opinion. Instruction number 15. As jurors, you will decide whether the defendant is guilty or not guilty. You must base your decision only on the evidence. Evidence usually consists of the testimony and exhibits presented at trial. Testimony is what witnesses say under oath. Exhibits are things like documents, photographs, or other physical objects. The fact that the defendant has been accused of a crime and brought to trial is not evidence. What the lawyers say is not evidence. For example, their opening statements and closing arguments are not evidence. Instruction number 16, presumption of innocence. Remember, the fact that the defendant is charged with a crime is not evidence of guilt. The law presumes that the defendant is not guilty of the crimes charged. This presumption persists unless the prosecution's evidence convinces you, beyond a reasonable doubt, that the defendant is guilty. Instruction number 17, proof beyond a reasonable doubt. The prosecution has the burden of proving the defendant guilty beyond a reasonable doubt. Some of you may have served as jurors in civil cases where you were told that it is only necessary to prove that a fact is more likely true than not true. In criminal cases, the prosecution's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. Instruction number 18, evidence closing. You must base your decision only on the evidence that you saw and heard here in court. Evidence includes what the witnesses said while they were testifying under oath and any exhibits admitted into evidence. Nothing else is evidence. The lawyer's statements and arguments are not evidence. Their objections are not evidence. My legal rulings and comments, if any, are not evidence. In reaching a verdict, consider all the evidence as I have defined it here and nothing else. You may also draw all reasonable inferences from the evidence. Instruction number 19, direct and circumstantial evidence. Facts may be proved by direct or circumstantial evidence. The law does not treat one type of evidence as better than the other. Direct evidence can prove a fact by itself. It usually comes from a witness who perceived firsthand the fact in question. For example, if a witness testified he looked outside and saw it was raining, That would be direct evidence that it had rained. Circumstantial evidence is indirect evidence. It usually comes from a witness who perceived a set of related events, but not the fact in question. However, based on that testimony, someone could conclude that the fact in question had occurred. For example, if a witness testified that she looked outside and saw that the ground was wet and people were closing their umbrellas, that would be circumstantial evidence that it had rained. Before you can find the defendant guilty of any charge, there must be enough evidence, direct, circumstantial, or some of both, to convince you of the defendant's guilt beyond a reasonable doubt. It is up to you to decide. Instruction number 20. The probative inferences from circumstantial evidence must be more than speculation and conjecture. Instruction number 21. You have heard evidence that the defendant engaged in an extramarital affair before the acts charged in this case. You may consider this evidence, if at all, for the limited purpose of showing motive. This evidence was not admitted to prove a character trait of the defendant or to show that he acted in a manner consistent with such a trait. Keep in mind that the defendant is on trial for the crimes charged in this case, and for those crimes only. You may not convict a person simply because you believe he may have committed some other acts at another time. Instruction number 22, do not consider punishment. In making your decision, do not consider what punishment could result from a verdict of guilty. Your duty is to decide if the defendant is guilty beyond a reasonable doubt. Punishment is not relevant to whether the defendant is guilty or not guilty. Instruction number 23, closing arguments. When the lawyers give their closing arguments, keep in mind that they are advocating their views of the case. What they say during their closing arguments is not evidence. If the lawyers say anything about the evidence that conflicts with what you remember, you are to rely on your memory of the evidence. If they say anything about the law that conflicts with these instructions, you are to rely on these instructions. Instruction number 24, objections. Rules govern what evidence may be presented to you. On the basis of these rules, the lawyers may object to proposed evidence. If they do, and I would say they have during the course of the trial, I will rule in one of two ways. If I sustain the objection, the proposed evidence will not be allowed. If I overrule the objection, the evidence will be allowed. Do not evaluate the evidence on the basis of whether objections were made. Instruction number 25, legal rulings. During the trial, I have made certain rulings. I made those rulings based on the law, and not because I favor one side or the other. Again, however, if I sustained an objection, if I did not accept evidence offered by one side or the other, or if I ordered that certain testimony be stricken, then you must not consider those things in reaching your verdict. Instruction number 26, judicial neutrality. As the judge, I am neutral. If I have said or done anything that makes you think I favor one side or the other, that was not my intention. Do not interpret anything I have done as indicating that I have any particular view of the evidence or the decision that you should reach. Instruction number 27, witness credibility. In deciding this case, you will need to decide how believable each witness was. Use your judgment and common sense. Let me suggest a few things to think about as you weigh each witness's testimony. How good was the witness's opportunity to see, hear, or otherwise observe what the witness testified about? Does the witness have something to gain or lose from this case? Does the witness have any connection to the people involved in this case? Does the witness have any reason to lie or slant the testimony? Was the witness's testimony consistent over time? If not, is there a good reason for the inconsistency? If the witness was inconsistent, was it about something important or unimportant? How believable was the witness's testimony in light of other evidence presented at trial? How believable was the witness's testimony in light of human experience? Was there anything about the way the witness testified that made the testimony more or less believable? In deciding whether or not to believe a witness, you may also consider anything else you think is important. You do not have to believe everything that a witness said. You may believe part and disbelieve the rest. On the other hand, if you are convinced that a witness lied, you may disbelieve anything the witness said. In other words, you may believe all, part, or none of a witness's testimony. You may believe many witnesses against one, or one witness against many. In deciding whether a witness testified truthfully, remember that no one's memory is perfect. Anyone can make an honest mistake. Honest people may remember the same event differently. Instruction number 28, law enforcement officer's testimony. You have heard the testimony of a law enforcement officer. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. It is up to you to give any witness's testimony whatever weight you think it deserves. Instruction number 29, in custody informant. You have heard from witnesses who may be classified as in custody informants. The law allows the use of such testimony. However, the testimony of an informant who provides evidence against a defendant must be examined and weighed by you with greater care than the testimony of an ordinary witness. Whether the informant's testimony has been affected by interest or prejudice against the defendant is for you to determine. In making that determination, you should consider, 1, whether the informant has received anything, including leniency in prosecution, personal advantage, or vindication in exchange for testimony. 2, other cases and the number of other cases in which the informant testified or offered statements against another, whether those statements are being used, and whether the informant received any deal, promise, inducement, or benefit in exchange for that testimony or statement, or believed that he was likely to receive some benefit from his cooperation. 3, whether the informant has ever changed his or her testimony. 4, the criminal history of the informant, not just limited to number of convictions, but also the level of sophistication gained through the informant's experience in the criminal justice system. And 5, any other evidence related to the informant's credibility. In sum, you should look at all of the evidence in deciding what credence and what weight, if any, you would give to the jailhouse informant. You should bear in mind that a witness who has entered into such an agreement with the government may have an interest in the case different from any ordinary witness. A witness who believes that he may be able to obtain his own freedom or receive a lighter sentence by giving testimony favorable to the prosecution has motive to testify falsely. Therefore, you must examine his testimony with caution and weigh it with great care. If, after scrutinizing his testimony, you decide to accept it, you may give it whatever weight, if any, you find it deserves. Instruction number 30, defendant not testifying. A person accused of a crime may choose whether or not to testify. In this case, the defendant chose not to testify. Do not hold that choice against the defendant. Do not try to guess why the defendant chose not to testify. Do not consider it in your deliberations. Decide the case based only on the basis of the evidence. Decide the case only on the basis of the evidence. The defendant does not have to prove that he or she is not guilty. The prosecution must prove the defendant's guilt beyond a reasonable doubt. Instruction number 31, fact versus expert witnesses. There are two types of witnesses, fact witnesses and expert witnesses. Usually a fact witness can testify only about facts that he, she can see, hear, touch, taste, or smell. An expert witness has scientific, technical, or other special knowledge that allows the witness to give an opinion. An expert's knowledge can come from training, education, experience, or skill. Experts can testify about facts, and they can give their opinions in their area of expertise. It is for you to determine the weight and credit to be given the testimony of each witness. You have a right to use that knowledge and experience which you possess in common with people in general in regard to the matter about which a witness has testified. You may take into account the ability and opportunity to observe and know the things about which such witness has testified, the memory, manner, and conduct of such witness while testifying, any interest the witness may have in the result of this trial, and the reasonableness of such testimony considered in light of all the evidence in this case. Use your common sense in evaluating all witnesses, including expert witnesses. You do not have to accept an expert's opinion. You may accept it all, reject it all, or accept part and reject part. You may also look at things like bias, consistency, and reputation. Give it whatever weight you think it deserves. Instruction number 32, separate consideration of multiple crimes. The defendant has been charged with more than one crime. It is your duty to consider each charge separately. For each crime charged, consider all of the evidence related to that charge. Decide whether the prosecution has presented proof beyond a reasonable doubt that the defendant is guilty of that particular crime. Your verdict on one charge does not determine your verdict on any other charge. Instruction number 33, elements of count 1. The defendant is charged in count 1 with murder. You cannot convict him of this offense unless you find beyond a reasonable doubt, based on the evidence, each of the following elements. 1, that on or about April 11, 2007, in the state of Utah. 2, the defendant, Martin MacNeill, is the person who caused the death of Michelle MacNeill and did so under the following circumstances. 3A, the defendant intentionally or knowingly caused the death of Michelle MacNeill. Or 3B, the defendant intended to cause serious bodily injury to Michelle MacNeill and committed an act clearly dangerous to human life that caused the death of Michelle MacNeill. Or 3C, the defendant acted under circumstances evidencing a depraved indifference to human life and knowingly engaged in conduct that created a grave risk of death to another and thereby caused the death of Michelle MacNeill. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you are not convinced that one or more of these elements has been proved beyond a reasonable doubt, then you must find the defendant not guilty. Instruction number 34. If the jury unanimously agrees that the defendant caused the death of Michelle MacNeill, the jury is not required to unanimously agree on which subsection of the murder instruction the crime was committed. In other words, the jurors may conclude that the crime was committed under either subsection A, B, or C contained in instruction number 33. However, the jurors do not have to unanimously agree under which particular subsection the murder was committed. Instruction number 35. Depraved indifference to human life means an utter callousness toward the value of human life and a complete indifference as to whether the actor's conduct will create a grave risk of death to another. To act with depraved indifference, the actor must do more than act recklessly. However, he does not have to have a conscious desire to cause death, nor does he need to be aware that the conduct is reasonably certain to cause death. In the context of depraved indifference murder, knowingly means that the person knew the nature of his conduct, that the conduct created a risk of death, and that the risk of death was grave. A grave risk of death means more than a substantial and unjustifiable risk. There must be a high likelihood that death will result. In order to find depraved indifference, you must evaluate all the circumstances surrounding the death from the standpoint of a reasonable person in the actor's position. In evaluating the evidence, you should consider the following factors: the social value of the defendant's conduct, the magnitude of the risk, the defendant's knowledge of the risk, and any precautions taken by the defendant to minimize the risk. Instruction number 36, serious bodily injury. Serious bodily injury means bodily injury that creates or causes serious permanent disfigurement, protracted loss or impairment of the function of any bodily member or organ, or creates a substantial risk of death. Instruction number 37, elements of count 2. The defendant is charged in count 2 with obstruction of justice. You cannot convict him of this offense unless you find beyond a reasonable doubt, based on the evidence, each of the following elements. 1, the defendant Martin MacNeill. 2, on or about April 11, 2007 in the state of Utah. 3, did with intent to hinder, delay, or prevent the investigation, apprehension, prosecution, conviction, or punishment of any person regarding conduct that constitutes a criminal offense. A, prevent by deception any person from performing any act that might aid in the discovery, apprehension, prosecution, conviction, or punishment of any person. B, alter, destroy, conceal, or remove any item or thing or other thing. C, make, present, or use any item or thing known by the actor to be false. Or D, provide false information to investigative authorities regarding a suspect, a witness, the conduct constituting an offense, or any other material aspect of the investigation. And 4, the conduct which constituted a criminal offense would be a first-degree felony. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you are not convinced that one or more of these elements has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Instruction number 38. The term investigative authorities includes law enforcement officers and the Office of the Utah State Medical Examiner. Instruction number 39. You are instructed that the criminal offense of murder is a first-degree felony. Instruction number 40, date of an offense is not a required element. When it is charged that a crime was committed on or about a certain date, if the jury finds that the crime was committed by the defendant, the proof need not show that it was committed at the time so alleged, but may be proved to have been committed sometime on or about the date alleged. Instruction number 41, offense requires conduct and mental state. A person cannot be found guilty of a criminal offense unless the person's conduct is prohibited by law and at the time the conduct occurred, the defendant demonstrated a particular mental state specified by law. Conduct means an act. An act is a voluntary movement of the body, and it can include speech. As to the mental state requirement, the prosecution must prove that at the time the defendant acted, he did so with a particular mental state. For each offense, the law defines what kind of mental state the defendant had to have, if any. The crimes for which the defendant is charged requires a mental state of acting intentionally or knowingly. Instruction number 42, inferring the required mental state. The law requires that the prosecutor prove beyond a reasonable doubt that the defendant acted with a particular mental state. Ordinarily, there is no way that a defendant's mental state can be proved directly because no one can tell what another person is thinking. A defendant's mental state can be proved indirectly. from the surrounding facts and circumstances. This includes things like what the defendant said, what the defendant did, and any other evidence that shows what was in the defendant's mind. Instruction number 43, motive. A defendant's mental state is not the same as motive. Motive is why a person does something. Motive is not an element of the crimes charged in this case. As a result, the prosecutor does not have to prove why the defendant acted or failed to act. However, a motive or lack of motive may help you determine if the defendant did what he is charged with doing. It may also help you determine what his mental state was at the time. Instruction number 44, mental states defined. A person engages in conduct intentionally or with intent or willfully with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. Knowingly or with knowledge with respect to his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or the existing circumstances. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Instruction number 45, four-person selection and duties. Among the first things you should do when you go to the jury room to deliberate is to appoint someone to serve as the jury foreperson. The foreperson should not dominate the jury's discussion, but rather should facilitate the discussion of the evidence and make sure that all members of the jury get the chance to speak. The foreperson's opinions should be given the same weight as those of other members of the jury. Once the jury has reached a verdict, the foreperson is responsible for filling out and signing the verdict form on behalf of the entire jury. For each offense, the verdict form will have two blanks, one for guilty and the other for not guilty. The foreperson will fill in the appropriate blank to reflect the jury's unanimous decision. In filling out the form, the foreperson needs to make sure that only one blank is marked for each charge. Instruction number 46. Should you, in your deliberation, have questions regarding any instruction or other issue, please reduce the question to writing, have it signed by the foreperson, and submit it to the bailiff. However, these instructions should contain all the information you need to deliberate. Instruction number 47, jury deliberations. In the jury room, discuss the evidence and speak your minds with each other. Open discussion should help you reach a unanimous agreement on a verdict. Listen carefully and respectfully to each other's views, and keep an open mind about what others have to say. I recommend that you not commit yourselves to a particular verdict before discussing all the evidence. Try to reach a unanimous agreement, but only if you can do so honestly and in good conscience. If there is a difference of opinion about the evidence or the verdict, do not hesitate to change your mind if you become convinced that your position is wrong. On the other hand, do not give up your honestly held views about the evidence simply to agree on a verdict, to give in to pressure from other jurors, or just to get the case over with. In the end, your vote must be your own. Because this is a criminal case, every single juror must agree with the verdict before the defendant can be found guilty or not guilty. In reaching your verdict, you may not use methods of chance, such as drawing straws or flipping a coin. Rather, the verdict must reflect your individual, careful, and conscientious judgment as to whether the evidence presented by the prosecutor proved each charge beyond a reasonable doubt. Instruction number 48. It is your duty to consider the evidence altogether, fairly, impartially, conscientiously, and without prejudice of any kind. You should arrive at your verdict solely upon the evidence introduced before you upon the trial. You should not consider nor be influenced by any evidence offered which was not admitted by the court, nor are you to consider any evidence given if the court ordered that the evidence be stricken. The law forbids you to be governed by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling. Both the state of Utah and the defendant have a right to demand, and they do demand and expect that you will conscientiously and dispassionately consider the weight of the evidence and apply the law as instructed by the court to reach a just verdict. The verdict must express the individual opinion of each juror. Is the state prepared to close?
We have one housekeeping matter, if Mr. Spencer and I may approach, Your Honor.